Attorney L. Reed Bloodworth is managing partner of Bloodworth Law, based in Orlando, Florida, with offices in Winter Haven, Florida. The Bloodworth Law probate team works with Floridians across the state in the cities and courts where clients live. Bloodworth Law answers the question, what is a summary administration? A summary administration is a shortened form of Florida probate. It requires that the value of an estate, less the value of exempt property from creditors, is not more than $75,000, or that a decedent has been dead for more than 2 years. For example, if a decedent died with $50,000 in assets, then it qualifies for a summary administration. Or, here's another example. If an estate is worth $200,000, but the decedent died 5 years ago, then it qualifies for summary administration. The reason for the 2-year rule is that there is a statute limiting creditor claims against an estate 2 years from the date of death to file a claim. The benefit of a summary administration is that a personal representative is not needed. Any beneficiary or the personal representative named in the will can petition the court for summary administration. All beneficiaries must either sign the petition or sign a waiver and join in the petition. Creditors do not necessarily have to be notified, so there is no 3-month creditor waiting period. Sometimes it's published after getting the order of summary administration, and this is done to close the 2-year window to 3 months. Summary administration is a much shorter time period, and while an exact time frame can't be gauged, it is much shorter than going through formal probate. Another shortened form of probate is the disposition of personal property without administration. This is very limited and only available to the person who paid the final expenses, such as funeral or medical bills. In a summary administration, the estate can only have exempt personal property such as a car or household furniture and non-exempt property like a bank account that does not exceed the amount of funeral expenses up to $6,000 or medical and hospital expenses from the last 60 days of illness. No real property is allowed. Only a probate or estate attorney knows whether a summary administration is possible. Talk with an experienced probate attorney at Bloodworth Law and find out how to protect you, your family, and your loved ones.